In the previous section, we explored how title represents ownership and how recording provides notice to the public. Now, we turn to the document that actually transfers that ownership, the deed. Every real estate transaction hinges on this legal instrument because it serves as the written evidence of the transfer of title from one party to another. A deed of conveyance is a formal, written instrument through which a property owner, known as the grantor, transfers ownership to another party, called the grantee. A deed is more than a formality. It is the vehicle through which real property changes hands. However, simply signing a deed does not make it effective. For a deed to legally transfer ownership, it must be properly delivered and accepted. Delivery and acceptance. Delivery means the grantor must be legally competent and intend to transfer ownership at that moment. The grantor cannot merely hand the document over, they must intend to permanently part with ownership rights. Acceptance occurs when the grantee takes possession or records the deed. Once the deed is delivered and accepted, title officially passes. If the grantee later loses the document, ownership remains intact. The deed cannot be reused to transfer ownership again, and returning it to the grantor does not reverse the transaction. In some states, ownership transfers only after the deed has been registered in a system known as the Torrent system. Arizona, however, does not use the Torrent system. Instead, deeds in Arizona are effective upon proper delivery and acceptance, and recording serves as constructive notice of ownership to the public. Requirements for a valid deed. For a deed to be legally valid, certain elements must be present. It must be in writing, identify a competent grantor and legitimate grantee, include a legal description of the property, and contain a granting clause that expresses the grantor's intent to transfer title. It must also include consideration, be signed by the grantor, and usually be acknowledged before a notary so that it can be recorded. Consideration is what distinguishes a contract from a gift. It can be valuable consideration, such as money, gold, or stock, or good consideration, such as love and affection. For example, if a grandfather deeds a house to his grandson out of love, that's good consideration. But if he only promises to do so later and changes his mind, the grandson has no legal recourse because no valuable consideration was exchanged. Recording a deed is not required to make it valid, but it is essential for protecting the grantee's interest. Recording provides constructive notice, informing the public that ownership has changed and preventing future claims against the property. Deed clauses and covenants. A deed consists of multiple clauses, each serving a specific purpose. The granting clause is the only clause required by law and identifies the parties, describes the property, and states the intent to convey ownership. The habendum clause, beginning with to have and to hold, defines the estate being conveyed, such as a fee simple or a life estate. The redendum clause or reserving clause establishes any restrictions, easements, or conditions that remain with the grantor, while covenant or warranty clauses provide assurances about the quality of the title being transferred. Common covenant clauses include warrant of ceasing. The grantor owns the property and has the right to convey it. Warrant of quiet enjoyment. The grantee's ownership will not be disturbed by others with superior claims. Warrant of further assurance. The grantor will take steps to correct future title problems. Warranty forever. The grantor promises to defend the title against all claims. Warrant against encumbrances. The grantor guarantees there are no undisclosed liens or restrictions. These covenants form the backbone of the various types of deeds used in real estate transactions. Types of deeds. Different deeds provide different levels of protection for the grantee. A general warranty deed offers the highest level of protection. The grantor guarantees ownership and promises to defend the title against all claims, past and future. Its overall covenant is, I own and will defend. A special warranty deed provides limited protection. The grantor warrants only against defects that occurred during their ownership but not before. Its overall covenant is, I own and will defend against my acts only. This deed is common in commercial or foreclosure sales. A bargain and sale deed implies ownership but offers no warranties. It is often used in foreclosure, tax, or trustee sales. Variations include the sheriff's deed, trustee's deed, and treasurer's deed. Its general covenant is, I own but won't defend. A quitclaim deed conveys whatever interest the grantor may have without any warranties. It is typically used to clear clouds on title, such as correcting a misspelled name or removing a previous spouse's interest. Its covenant is, I may or may not own and I won't defend. Other deeds include the beneficiary deed, unique to Arizona, which transfers property automatically upon the owner's death to a named beneficiary without probate. The disclaimer deed, which allows a spouse to disclaim marital interest in property held as sole and separate. And special purpose deeds, such as executor's deeds, guardian's deeds, and patent deeds used for court or government transfers. Transfer tax and affidavit of value. While some states impose a transfer tax on real estate sales, Arizona does not. However, an affidavit of value must accompany every deed at recording. This affidavit includes the purchase price and signatures of both parties to help the county assessor determine property value for taxation purposes. Recording fees are usually split between buyer and seller according to contract terms. Example in practice. Imagine that Sophia sells her Phoenix home to Elijah using a general warranty deed. Months later, a long-forgotten lien from a previous owner surfaces. Because Sophia conveyed title with a general warranty deed, she is obligated to defend Elijah's ownership, even though the defect predated her ownership. In another case, a trustee conveys foreclosed property to a buyer using a special warranty deed. If a title issue later arises from before the trustee's ownership, the buyer's title insurance, not the deed, provides protection. Review summary. A deed is the legal instrument that makes title transfers possible. To be valid, it must be written, signed, and delivered with intent, accepted by the grantee, and usually acknowledged for recording. The granting clause conveys ownership, while covenant clauses establish assurances about title. The general warranty deed provides full protection, while the special warranty, bargain and sale, and quitclaim deeds provide less. Arizona law also recognizes beneficiary and disclaimer deeds for estate and marital transfers. Recording provides public notice and secures ownership priority, while the affidavit of value documents sale terms for tax purposes. Discussion. Why is delivery and acceptance crucial to a valid deed transfer? Answer. Because a deed does not convey title until the grantor intends to transfer ownership and the grantee accepts it, either through possession or recording. What distinguishes a general warranty deed from a special warranty deed? Answer. A general warranty deed protects against all title defects, past and present, while a special warranty deed only covers defects arising during the grantor's ownership. Why might someone use a quitclaim deed? Answer. To clear title defects or remove potential claims, such as releasing a spouse's interest after divorce or correcting a clerical error in a previous deed. How does a beneficiary deed benefit Arizona property owners? Answer. It allows owners to transfer property directly to named beneficiaries upon death without probate, maintaining control during life. Closing remarks. Understanding deeds is essential for every real estate professional. Deeds not only prove ownership, but also define the promises, limitations, and liabilities that come with transferring property. Whether preparing, reviewing, or recording a deed, the agent's role is to ensure all legal requirements are met, that the client understands the level of protection being conveyed, and that the instrument is promptly recorded to safeguard ownership rights.